Viewers, welcome back to the show. Before the break, we said we're going to be talking about superannuation benefits and insurance benefits. Just in general, Sarah, what does that mean?
Tony, all employees in the country have an entitlement to superannuation benefit payments from their employer. It's legislated. Attached to that account, generally, most people will also have insurance in the form of income protection or total and permanent disability, which is a form of disablement or illness cover.
Okay. Don, in addition to that, there's also what we call income protection and trauma benefits. In brief, what does that mean?
Well, income protection, so if you're incapacitated for employment, you get your insurance coverage for the period that you've had off work, and it depends on the insurance coverage that you seek as to how much is paid to you. And then trauma insurance is if a certain condition happens or certain event happens in terms of broken bones, cancer, heart attack, there's a set insured amount for it, Tony. So like if
it's a defined benefit.
So if you've been diagnosed as, say, cancer, these coverages could go up to over $1 million, Tony, as we know. So look, and particularly people who are self-employed, quite important to have those type of insurance coverages because if you're self-employed, there's no work cover. Sometimes in those circumstances, no work coverage, so you're left on your own. So at least you've got this insurance policy.
An important thing to note there, Don, too, is that a lot of people think they don't need income protection cover because we've got TAC cover and work cover in Victoria. But income protection is very important, where if you have an accident at home that stops you from working, you've still got that income coming in while you're recovering.
I want to address this to the tradies and subcontractors out there. A lot of them think they're picked up by the primary employer or builder if they're working on a site, but if they're a subby, they should have their own work cover insurance and or income protection. So be wary of that. Speak to your financial advisors and or your accountants, because I'm amazed at the number of people that come to see us that don't have any insurance, and they're not deemed employees because they're working from site to site. So I just think it's something you've got to look at because it's been happening on a regular basis. Now, Sarah, if you want to lodge a claim for superannuation, total and permanent disability benefits, what is the process?
The process for lodging a claim, Tony, is that there's forms that are required to be completed and sent back to the fund. These include medical reports from the treating general practitioner and specialist. A lot of people misinterpret what information is required, though, to lodge a claim. It's not just a matter of lodging some claim forms with a fund like you do for a car insurance claim and they'll pay out. In instances now, the funds, and in particular their insurers, are looking quite closely at the particular instances of the injury and their ability to take on some sort of other employment in the future, which a lot of people don't sort of grasp in putting these claims in. And
Don, just on the point Sarah's making, the person that lodges a claim has also got to lodge medical evidence to support that they've got a total and permanent disability benefit as defined in the policy.
Well, that's right. I mean, it's an insurance policy in the end, so there's definitions in that policy as to what is total and permanent disablement, and so to have access to that amount, you must satisfy the definition. And Sarah, can you give us examples of actually what is the usual definition of total and permanent disability?
Generally, and this is a generalisation for most funds, requires that you suffer an injury or illness whilst you're employed, and that injury or illness keep you off work for a period of 6 consecutive months. Most people will find that part is not difficult to prove. The second part of the definition is what generally ends up with cases being in court, Don, and that is that the plaintiff or the worker has to show that because of that injury or illness, it's unlikely that they'll ever be able to return to work for which they're suitably qualified for. And the funds and insurers in those cases can take into consideration your previous education, training and experience and transferable skills that you may have.
So Sarah, the point you're trying to make is that the people that are lodging these claims must undergo rehabilitation, is that correct?
A lot of the funds will require that they have had all forms of treatment and rehabilitation before they'll assess the claim, and then they look quite closely at what you've done previously. So it's not a matter of just saying, I can't do the job that I was doing, therefore I satisfy the definition, I can get paid out. The fund and the insurers will look at what you've done previously, whether it be 10 years ago or 20 years ago. If you've still got those skills and they can be transferred into a new type of employment, they will scrutinise that quite closely. And this is why it's so important that people seek legal advice about these matters before lodging the claim. Once the information is before the fund, it's really, really difficult. They'll set themselves in a certain way in terms of the claim, and that it's very difficult then to change that.
A lot of these matters where people lodge total and permanent disability claims and trauma benefits and sickness benefits, the cost is on the individual to provide these medical reports. The only time that the insurer pays is if they send you to a medical assessment themselves. It's a bit harsh, but that's how it is, isn't it?
Look, unfortunately, it's particularly after you are paying for the premiums, and then you have to go off and prove it all. But look, Sarah, with these total and permanent disablement, look, first of all, it doesn't necessarily have to be a traumatic injury. It could be just illness, so heart attacks, cancer and all that. Secondly, with the actual definition of being able to return to work, they don't necessarily differentiate between part-time and full-time work. So even if you were saying working full-time before the accident or the trauma or the illness, and then return to part-time work, you still may not be able to get your access to that total and permanent disablement fund.
That's right, Don. In the past, this particular question of full-time versus part-time return to work has been quite... it's been really difficult for the courts to make a determination. In the past, they've found that if you can't return to the duties and the hours that you were doing before, you still satisfy the definition. Unfortunately, more recently, there's been some Court of Appeal decisions that have said that if you have a capacity to return to work, even if it is just part-time, and it's comparable to what you were doing, then you will not satisfy the definition.
It's a case-by-case basis, guys, and we'll turn to some of those cases later on. Also, Sarah, trauma benefits. One of the main trauma benefits that we're familiar with is in the construction industry, IncoLink. Can you tell us a bit about that?
IncoLink is a redundancy fund that was set up for builders because they generally, don't stay on the same job for long periods of time. Jobs move around, and attached to that is what's called trauma cover and top-up cover. Now, the top-up cover is the difference for someone who's suffered an injury for a 12-month period after they've been on weekly payments or TAC payments. Trauma benefits are a lump sum benefit that a worker is entitled to once they satisfy a very specific definition. Unfortunately, recently, the trauma benefit entitlements of workers in this industry has changed, and it now is a tabled list of injuries. So paraplegics, quadriplegics, broken arms, they have to be a permanent injury that makes you totally disabled.
Don, the workers don't realise you've got to satisfy so many tests to get over, so many hurdles to get over the test to get these benefits, and of late they take a percentage of disability and give you 10% of 150,000 or 10% of 250,000. So the law has changed a lot, hasn't it? It
has, Tony. And look, I think it's like we keep telling everyone on this show, you should seek legal advice if you're in those circumstances. I mean, for example, IncoLink, actually, I've come across a few times now, is that if you have IncoLink insurance and you're injured, not at work, not going to work, say in a motor vehicle, you're actually not covered by IncoLink. So there are some exclusions. So definitely you need to seek some legal advice if you're in those circumstances.
Guys, we've got to go to a sponsors break. Viewers, stay tuned. We'll be back with some cases just after the break.